So today, the Supreme Court is hearing oral arguments on the legal concept around birthright citizenship. Now, this is something that Donald Trump has been keen on challenging in the court systems, along with a lawyer close to him, John Eastman. Now, if you are not familiar, the concept of birthright citizenship in the United States is the idea that if you are born in the United States, you are an American citizen, regardless if your parents were here in the country legally, illegally, whatever. And it is safe to say there is a lot of false information surrounding the idea of birthright citizenship and how it has played out over the last 150 years since it was ratified with the 14th Amendment. So today we are going to take some time and explain the exact debate surrounding this idea. But in order to do that, we have to take a couple steps back in time. We have to go back to the establishment of the birthright citizenship clause in the United States. This was established in United States law in 1868 when the 14th Amendment was ratified. Now, the amendment reads, quote, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the states wherein they reside. Now, the court has ruled on this multiple different times. There have been multiple legal challenges to the exact interpretation of what this law meant. The court ruled in 1998 that this applies to children of immigrants regardless of their legal status. And the current debate really revolves around the idea that children of undocumented immigrants should or shouldn't be considered citizens. Even if they're born in the U.S., should they or should they not? This really all swarms around a phrase in there. And subject to the jurisdiction thereof. All persons born or naturalized in the United States and subject to the jurisdiction thereof. We're going to kind of get into that just a little bit more here in just a second. But ultimately, this has been a very, very big target for Donald Trump going into this. Now, after Donald Trump passed an executive order in 2025, I believe in February, he issued an executive order really to deny birthright citizenship to children of non-citizens. Now, courts blocked it immediately after roughly 22 attorney generals sued the Trump administration over this, and it is now being discussed in court today. And I think you should just take a second to realize it is a huge step that the Supreme Court even took this up. I think there was a lot of people who were surprised that the Supreme Court decided to take this case up, that they were even going to hear oral arguments on this and then actually issue a ruling on it. There's a lot of people who I don't think they saw this coming. So this was obviously a big step for Donald Trump to see that the Supreme Court was actually going to pick this case up. Now, the historical foundations around birthright citizenship really trace back to English common law, and notably with Kelvin's case in 1608, which establishes citizen by birth within a sovereign dominion. Now, in the U.S., this principle was affirmed in the case of Lynch versus Clark in 1844, which held that a child born to a temporary visitor as a natural-born citizen. And now the 14th Amendment, ratified in 1868, explicitly, they guaranteed citizenship to all persons born or naturalized in the United States and subject to the jurisdiction thereof, addressing the exclusion of African Americans. We knew there were children of slaves who were wrongfully denied citizenship, wrongfully denied rights. This was there to make up for that. And in the Supreme Court case, the United States versus Wong Kim Ark in 1898, further clarified that children born in the U.S. to immigrant parents, including those of undocumented status, are citizens, reinforcing this doctrine of right of the soil. Now, the historical debates during the 39th Congress include discussions on citizenship for children of Chinese immigrants, with Senator John Conness supporting their inclusion, highlighting that the amendment's broad intent. And then, of course, there was the Indian Citizenship Act of 1924, which later extended citizenship to Native Americans, addressing previous exclusions, like in the Elk versus Wilkins 1884 case, which basically said that because a Native American was born on tribal land and had allegiance to another jurisdiction that was not the United States, they were not a citizen. They could not vote in an election. And proponents that favor birthright citizenship argue that it is a fundamental right that prevents the creation of hereditary non-citizen caste, vulnerable to exploitation. Now, this aligns with the 14th Amendment's purpose to ensure equality post-Civil War for African Americans. Now, this is truly the belief for people that favor birthright citizenship. They assert that it integrated first-generation Americans quickly into society, and it also simplified citizen proof, requiring only a birth certificate, and promotes social cohesion by ensuring all people born in the U.S. can participate fully in the life here in the United States, which I think is kind of a wonky argument. To be honest, out of the 20 developed nations, there are only 2 nations that actually have birthright citizenship, the United States and Canada. It's like, and really, if you're looking at the legal authority of this, the legal authority for this view that supports birthright citizenship says that the Supreme Court in the Wong Kim Ark interpretation case says that, subject to the jurisdiction thereof, to include undocumented workers and only excluded foreign diplomats and those on foreign warships. That was it. That was it. It did not extend to non-citizens or even people who were here legally but maybe weren't citizens. It only excluded people. Who were foreign diplomats who had children in the United States. Now, the argument against birthright citizenship, the Heritage Foundation, they are a big proponent of this right now that push a lot of these ideas, argue that the 14th Amendment's, quote, jurisdiction refers to political allegiance to another entity, which would then mean it excludes children of undocumented immigrants, tourists, and diplomats. They cite historical cases like the Slaughterhouse case from 1872, the Elks versus Wilkins case of 1884, which denied citizenship to certain groups due to allegiances elsewhere, suggesting that the amendment was not intended for illegal aliens. They claim that the U.S. versus Wong Kim Ark applied to lawful permanent residents, not undocumented immigrants, and argue current practice is based in executive fiat, not law. The executive branch has basically made this law. This is what they're going off of, not that this is what is in the Constitution. There is also a lot to highlight when it comes to the practical concerns about this, such as birth tourism or anchor babies. They estimate that roughly 340,000 children born to unauthorized immigrants in the U.S. in 2008, which was roughly 8% of the births in that year. They propose that legislative clarification with states like Pennsylvania and Arizona, who considered efforts to deny automatic citizenship, especially when opposition grew in the late 1990s. Now, a lawyer who has pushed very, very hard behind this idea, his name is John Eastman. John Eastman has this central idea that the 14th Amendment Citizenship Clause, which states all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States, does not mandate automatic citizenship for everyone born on U.S. soil. He says, or the way he interprets this, is that subject to the jurisdiction thereof as requiring complete jurisdiction, meaning full and exclusive allegiance to the United States, which means it would exclude children born to parents who are temporary visitors, diplomats, or illegal immigrants, as these parents had allegiances to other countries. He solely bases his argument in the historical context of the 14th Amendment. Now, the 14th Amendment was ratified in 1868 to address citizenship for freed slaves post-Civil War. And he points to the Civil Rights Act of 1866, which granted citizenship to all persons born in the United States and not subject to any foreign power, suggesting that there was a much more narrow intent when that bill was passed. Now, there was a senator at the time, Senator Lynn Trumbull, who had statements when he was very key in passing this bill, or getting the 14th Amendment into law, into the Constitution. He basically said that the statement to subject to the jurisdiction means, quote, not owing allegiance to anyone else. Not owing, and if you're an undocumented immigrant in the United States, you have allegiance to another country. You have allegiance to your home country. And it aligns with the 1866 Act, the Civil Rights Act, that indicated that the amendment excluded those who are foreigners who have foreign allegiances. John Eastman also draws on different Supreme Court precedent to support his view. In the Slaughterhouse case of 1872, the court noted that subject to its jurisdiction excludes children of foreign diplomats and citizens born within the U.S., implying a requirement for allegiance. Similarly, in the Elk versus Wilkins case in 1884, they held that John Elk, a Native American, was not a citizen because he owed allegiance to his tribe, not the United States, reinforcing the need for, quote, complete jurisdiction. There's also been many legal scholars who have interpreted the subject to the jurisdiction as full and complete jurisdiction, not partial jurisdiction, consistent with a foreign allegiance. There's also a lot when it gets like going back to the United States versus Wong Kim Ark, which is a very pivotal part of John Eastman's argument. He critiques this ruling from 1898, really, and often cites it as establishing birthright citizenship. This was what established birthright citizenship for people who were here who were not citizens. He argues that the case specifically addressed a child born to parents who are lawful permanent residents here, who are barred from citizenship by treaty but fully subject to U.S. jurisdiction. Remember, some of the exclusion acts where they were not allowed to come here. They were not allowed to be permanent residents here. Now, Easton contends that extending this ruling to children from documented immigrants to undocumented immigrants or temporary visitors is a misinterpretation, as the court's broader language on birth alone is not binding. It's not a binding precedent. He notes that the Supreme Court has never formally held that children of illegal immigrants or temporary visitors are automatically citizens. There's been cases that are close where it is interpreted that the ruling from the Supreme Court rules on that, but there's not been a direct court case that rules directly on illegal immigrants and their children. And that's why I think it is a big deal that Donald Trump was even able to get his day in court with this. And it is a big deal that he was able to do this. Because Eastman rejects the notion that the 14th Amendment codifies English common law, the citizenship by birth or location, arguing that it was explicitly rejected by the Declaration of Independence, which emphasizes consent and breaking allegiance to the British Crown. He frames birthright citizenship as a feudal concept inconsistent with American principles of consent-based governance, aligning with a more Claremont Institute view that citizenship should be rooted in allegiance, not mere territorial presence, not just the fact that they were born on the land. And finally, Eastman argues that automatic birthright citizenship acts as a magnet for illegal immigration, undermining Congress's power over naturalization under Article 1, Section 8 of the Constitution. He highlights that, quote, birth tourism and anchor babies as practical issues, estimating significant numbers of births every single year that occur to unauthorized immigrants, which he sees as a policy that he sees where we need policy changes. In his view, supports legislative or executive action to clarify the citizenship clause. And that's exactly why Donald Trump issued Executive Order 14160, issued on January 28th, which directed the government to interpret the clause to exclude children born to undocumented or temporary present individuals in the United States. And this is a huge step, like we said, that the Supreme Court is even considering this here. It is a huge step. But that is really the two sides of it. You see the people who are against it, they think there's a lot more to be said when you're talking about subject to the jurisdiction thereof, saying that you have to have full allegiance to the United States. You cannot have allegiance elsewhere if you're going to be a citizen here. And the people who are very much in favor of it believe that there has been multiple court cases that have settled this. Now, it is correct. The people who are against this, they are correct in saying that there has not been a Supreme Court case that specifically goes after the children of undocumented immigrants. That's very clear. And, I think the view, I'm not saying it's wrong, and I'm not making a ruling on this because I think I can see it both ways. I probably lean a little bit more towards I'm against birthright citizenship. I think I'd be against it for illegal immigrants. I'd be okay with a constitutional amendment that, allowed legal immigrants here. If you came here legally and you weren't on a temporary protected status visa here, if you came here legally and were a lawful permanent resident, okay, then I would be okay with that. But for illegal immigrants, for tourists, I just don't think that's okay. I don't know how you can have a country, how you can have a state when your borders are that lax. I just don't know how you can do that. But that is both sides of the argument on birthright citizenship. The ginormous, massive debate finally explained. Let me know if you have any questions. Let me know your thoughts down below. Are you for or are you against birthright citizenship? How do you feel that the Supreme Court should rule? As always, drop down below, hit that subscribe button. Make sure you never miss another video from us again in the future. And folks, we will catch you next time.